Thank you. The member for Maroubra.
You're up for election, don't you?
Thank you, Mr Acting Speaker. I rise to lead for the opposition on the Work, Health and Safety Amendment Bill 2013. Mr Acting Speaker, from time to time in this place issues arise in the context of so much crossover between the two parties, between the government and opposition sometimes, that are so philosophically held and strongly held as a matter of belief that there is often no accommodation or chance of accommodation. This issue of work health and of the Work Health and Safety Act and this bill is one of those issues. On this side of the House, we believe very strongly in a very, very strong workplace health and safety and occupational health and safety regime. Indeed, to be, I would suggest, one of the hallmarks of the previous Labor government and its predecessors over a very long time. We were therefore bitterly disappointed, but not surprised, when the government in its infancy, moved with undue haste and speed and without any consultation with either, for example, the Chief Justice of the Industrial Court, His Honour Justice Boland, or anybody else for that matter, to begin immediately dismantling that legislation simply because, for them, it was a matter of their core belief that it was too loaded in favour of employees. One of the first things that the government did was to lead an assault on the Industrial Relations Commission and Industrial Court that really continues to this day. We had in the Industrial Court a jurisdiction where its adjudicators held the same status as a Supreme Court judge. They were experienced, they held the requisite expertise in those sorts of specialist matters, they were well resourced, and having the general criminal jurisdiction of the state hear prosecutions and applications that arose from workplace injury or death had already been tried and, on our side of the fence we say, not failed, but could have been improved by having a specialist jurisdiction to hear them, and so we created one. And it worked not perfectly, no jurisdiction in the law worked perfectly, but it was as good as you could get, I would suggest. What happened with the passage of a number of bills in 2011 was the dismantling of the Occupational Health and Safety Act and the introduction of the Work Health and Safety Act and the movement of matters from the Industrial Court and Commission over to the District Court and Local Court, with the exception that certain matters where a death resulted would proceed on indictment to the Supreme Court. We didn't agree with that then, and we don't agree with it now. But the fact is that the government cocked it up in that legislation, and if they didn't, we wouldn't be here seeking to remedy that mistake. Well, it is. Otherwise, I wouldn't be standing here talking about it. So the validity of the jurisdiction to hear those prosecutions was challenged in Empire Waste Pty Limited and Dean Baldwin against the District Court of New South Wales, and I'm told that there are about 70 matters where the ramifications of that challenge are relevant. We won't oppose this bill in this place But we do we don't need to reserve the right, we do foreshadow that we'll be looking seriously at making whatever amendments we can in the other place to halt and reverse the transfer of those matters from one jurisdiction to a jurisdiction that doesn't want it, the district court. Its judges don't want it, its chief judge doesn't want it. It's not a resource set up to hear it, and since they've been moved over, there have been no additional resources or insufficient resources applied to the district court to help them deal with the new workload. So we don't agree with that then. It was a bad idea in 2011 and it's a bad idea today, even as imperfect as it is. The government got it wrong and we'll do what we can in the other place to remedy that if we can, if this bill allows it. The second major aspect of this bill is that it addresses another technical issue, this one dealing with the filing of prosecutions. It's been the legal position certainly and the practice for some time under the Occupational Health and Safety Act that proceedings brought under that Act for breaches of workplace safety were brought by a work cover inspector. Now, as a matter of practice, the initiating proceedings were customarily signed by the inspector in whose name the proceedings had been initiated. But over time, it may have been the case that initiating proceedings were signed not by the inspector, him or herself, but by lawyers working in work cover. That's not a problem in any other jurisdiction, where statements of claim, for example, are signed by the plaintiff's lawyer, but it might lead to a situation here where certain proceedings brought under the OH&S Act might be compromised or even struck out. We can't allow that to happen, and we agree with the government that that situation should be remedied. So we do not have any disagreement with that aspect of the bill that seeks to remedy that situation and to protect matters brought under the OH&S Act that are on foot or may have be under challenge of being struck out. But I do reiterate to the House that we don't agree with the conferral of the jurisdiction upon the District Court or any other court, and that if we can seek to remedy that situation in the other place, we will.